recommendations, right? Building on the lessons learned and also the good practice of cooperation that we have around here. So I think that none of our esteemed panelists need an introduction. We met some of them already this morning, so I'll skip their bios. And then I will going to invite them, each of them, to make their intervention for no more than, initial intervention, no more than 7 minutes, right? So, and I will start with Astrid. Astrid, you are the UN Special Rapporteur on the right to a clean and healthy environment. So I think that you could really set the scene for us, no? First and foremost, by telling us what the state's obligations in relation to this right are, also in the light, particularly in the light of the formal recognition of this right, which happened at the international level in 2022 and in some regional level even earlier. And also maybe we can discuss with you how we can ensure the fulfillment of states' obligations, how the fulfillment of state obligation is actually monitored and assessed at the international and regional level. So Astrid, over to you, 7 minutes, thank you.
Thank you very much, Federica, for chairing this panel, and good afternoon to all of you. And I'm really honored to be here and to participate and learn from all international and regional human rights mechanisms about how we can better collaborate, but also implement the right to a healthy environment. And thinking about how to take a stock of international and regional frameworks and think about also the main aspects and implementation of the right, I want to highlight 3 main points. The first one is about what is the framework that we're talking about, what is the status of the human right to a healthy environment. The second one is about, I want to share with you some findings regarding the implementation of the right to a healthy environment and the gaps that I saw. And at the end, to talk about a few priorities. So in the first place, in relation to the framework, today it's very clear that the right to a healthy environment and the right to a clean, healthy and sustainable environment is expressly recognized as a human right to everyone and everywhere. And this is not only, as we know, after the recognition in the Human Rights Council in 2021 and the 2022 resolution from the UN General Assembly, but also because we had a historical recognition with a vast political support at the UN General Assembly. And that was a process that took 50 years. So the first thing that I want to highlight here is that the recognition at the UN didn't start there. It was a process, and the UN recognition in the General Assembly was, in a way, the ending of all these 5 decades of conversations about the right to a healthy environment and the importance for the implementation of human rights. The other, of course, the element that I want to highlight is the International Court of Justice advisory opinion on the obligation of the states in relation to climate change that last July 23rd recognized and concluded that the right to a healthy environment is a precondition for the enjoyment of all human rights. And they also recognize that the right to a healthy environment is interdependence between other human rights, and it's inherent and essential for the enjoyment of all human rights. And the court also concluded that, and I quote, insofar as states parties to human rights treaties are required to guarantee the effective enjoyment of such rights, it is difficult to see how these obligations can be fulfilled without, at the same time, ensuring the protection of the right to a clean, healthy, and sustainable environment as a human right. This right, as we know, is also recognized regionally at the African and Inter-American system since the 80s, and we're seeing also, as we heard this morning, by the Arab Charter and the ASEAN Declaration since 2012, and I really look forward for the hopefully soon declaration in next month from ASEAN as well. And of course, there's a process at the Council of Europe. In addition to that, today, 85% of states globally recognize the human right to a healthy environment. So based on the above, we can today say and conclude that the right to a healthy environment is part of customary international law, because we see general practice of states, but also opinion juris. In relation to the lessons learned, the report that I presented last year to the General Assembly, I evaluated the implementation of the right to healthy environment, and including main obstacles and challenges that I will summarize and only mentioned these challenges, including the economic model and unsustainable development. There's also a current and worsening consequences of the triple planetary crisis that have been lived everywhere. There's a rule of law, which is in addition to another challenge regarding the weakening of existing policies, legal frameworks, and institutions. And this is something that I think both international and regional organizations can address, and we should address together, because there's a wave of deregulation that unfortunately is happening globally. There's also limitations to access to information, public participation, and access to justice. War, conflict, and illegal activities are also impacting the right to healthy environment heavily, and also increased risk to environmental human rights defenders and the closing of civil spaces. And there's specific challenges for people and groups in vulnerable situations. These challenges, one of the aspects that me and other special procedures have identified, and also mechanisms, are the undue influence of some businesses and sectors. And this is being reflected in different ways, including at international negotiations with the wave of deregulation and closing of civil space, also with the difficulties of controlling some businesses that are behind the environmental, climate change, and biodiversity laws crisis, and misinformation and even SLAPS, which is this litigation against public participation. There's other example of this undue influence includes state dispute settlement mechanisms that unfortunately today we're saying that are being used to protect investors' interest against the protection of the right to a healthy environment and other human rights. So third, and thinking about the time and identifying the priorities, there are many things that can be done, of course, but I want to share three main aspects. First of all, advancing the legal recognition of the right to a healthy environment, and of course, its implementation is key. And it has shown how in regions, including African and the Americas, how this works. The effective enforcement of existing frameworks and strengthen the rule of law to ensure compliance with existing obligations is key, including how to review and update the frameworks that we already have. Improving the protection of environmental defenders, including the participatory measures, and intersectional and making sure that there's an intersectional and inclusive approach is key to grant civic spaces and to be able to advance the solutions that the triple planetary crisis is happening. In this regard, I think that one of the key opportunities that we have today is how to understand and implement the legal obligations that states have that we already are seeing from the advisory opinions from ITLOS on the law of the sea, from the Inter-American Court on Human Rights, and from the International Court of Justice, that gives and clarifies states' obligations in relation with the right to a healthy environment, but also the climate crisis. Also, there's this new process of the advisory opinion at the African Court. These spaces give a very interesting opportunity to collaborate and to use the standards that the mechanisms have been developed. Definitely learning from these mechanisms and extracting the lessons learned and helping not only to implement these advisory opinions, but also implement the decisions from different courts on specific cases that should be used both for these cases, these situations, but also to prevent these situations to happen again elsewhere. And with this, I really look forward to this dialogue and to, from the mandate, coordinate and better implement the right to a healthy environment. Thank you very much.
Thank you very much, Astrid. There is a lot of meat to discuss further, and we have taken a step forward, indicating that the right to a healthy environment is part of customary law. So I'd love a reaction about this. But let me turn to Michael now. Michael, you are a member of the UN Committee on Economic and Social Rights. So what is the current state of play at the committee with regard to the right to a healthy environment, considering that the covenant didn't really include decades ago that this right? Michael, over to you, 7 minutes. Thank you.
Thanks a lot. And I'm pleased to be here and also in this exchange with all these regional mechanisms. First, because our committee has already invested a lot in this exchange. We had exchange with the Council of Europe, the Social Committee of the Council of Europe with Javier, who was twice with us, or the Asian Commission of Human Rights was visiting our committee, I think 2 years ago or 1.5 years ago. So I think these exchanges are extremely important. Yeah? Secondly, I also represent the other two letters of NIRMS, yeah, which is National Institutions. I'm the Deputy Director of the German Institute for National Human Rights Institutions. I see my colleagues from Morocco. So that's also an important part that we collaborate, and we need these regional mechanisms as well. What I want to say is on Friday, our session ended of the Committee on Economic, Social and Cultural Rights, and we finally adopted a general comment on economic, social and cultural rights and the environmental dimension on sustainability. So this is online since an hour or so. Yeah, I checked it this morning. I haven't even my own printed a version, but it's now out, and it was a longer process also involving 5 regional consultations. We even did 5 consultations with children, and we had also a day of general discussion where we had a lot of UN institutions, Commission on the Right to Development, and special rapporteurs there, your predecessor, and so that was all the background. Yeah. Now we have a consensus adopted text, which I highly recommend to read. I will say some things which is in maybe of importance. Let me say by starting, what we do is we say the economic, social, cultural right is a covenant which is there. Yeah? You are asking the question, do we need a lot of new instruments or tools? Maybe we don't need a lot of instruments, but we have to have an interpretation which is guided by taking the right to clean, health and sustainable environment into consideration when implementing the covenant. Yeah, and that's what we did, I think, with our text. We say at the beginning, we first recognize the right as an autonomous human right, but then we say also it's derived also from our covenant. Yeah, if you look into the right to health, the right to an adequate standard of living, or the right to culture, you can't have them without this, yeah, even if it was not mentioned here. So I think this double combination is important to say these economic, social, cultural rights needs the recognition of that right and the interrelation. And the interrelation is several, or at least in two directions. Yeah, the one is we observe that more and more the enjoyment of economic, social, cultural rights is really threatened by changes in the environment, particularly climate change. Yeah, heat waves, the working conditions for construction workers. You can have so many things. Yeah, the displacement because of floods. The Indus flood in Pakistan had 33 million people affected here. So if you look at this and the housing rights, then you see the relevance is extremely high. Yeah. On the other hand, we realize if there is no functioning environment left, the realization of these rights is also very difficult. Yeah. So for the sheer implementation of economic, social, and cultural rights, you need to have at least environmental framework conditions which allows still farmers, pastoralists. Yeah, that's not small groups. Yeah, 2.5 billion farmers, 800 million pastoralists. It's a majority of those who are poor. Yeah. So if we have to talk about this realization of our covenant rights, you are in the middle of where this goes hand in hand. Yeah. So therefore, we try to have a practical interpretation how this can be applied to our covenant. Yeah. And in the general comment, I highly recommend reading. Is first that we started to look into our key concept. Yeah? We have, for example, the key concept of progressive realization. Yeah? So is there any limit to progressive realization when you have planetary boundaries? No, it's not. Yeah, but what does it mean to talk about progressively realizing rights when you have limits? Yeah, so you need to totally differently think about distributional impacts. Yeah, who has to take care of focusing on particularly vulnerable groups or marginalized groups, which needs to come first. Yeah, and you have to think about this between states. Yeah, because we have also some who has polluted a bit more than others to be carefully in this. Yeah, so this double, let's say, dimension of injustice needs to be factored into account. Yeah. Secondly, we say use the maximum of the available resources. What does it mean? The maximum of all fossil fuels, the maximum of all other resources? Is that our goal? So it's meant to the implementation of the rights, yeah, but it needs also to think about that we have to Article 1 of our covenant to think about how many natural resources can be used and what does it mean if we take decisions not to use them all. Yeah, so that needs to be reflected. Yeah, and we start discussing, therefore, for example, when is it a retrogression? when you have to limit maybe to the resource use because of the limits which are there. It's not a retrogression, yeah, but it becomes a retrogression when you don't take care of those who are particularly affected, when you use not enough resources. So I think in these aspects, the text looks really into these difficult issues, how to realize these economic, social, cultural rights in a limited environment, yeah, and do it carefully by giving enough attention to those who are potentially extremely affected. Yeah. What we have also a big issue, another component, key concept is international cooperation and extraterritorial obligation. And this is extremely important. Yeah, you have all these business interventions in mining, in large development projects. We have all the development aid going into this direction. So it's extremely important to think also about this component of international cooperation. We need so much support to poorer countries. When we make state reviews, we can see how often states are also overwhelmed, yeah, by the consequences of climate change. Yeah. So having this in mind shows also these key concepts of the covenant are extremely important. What we then do in the text is we go through, for example, then the different articles of our covenant. So we talk about what does it mean to think about this in the terms of, let's say, the right to work. Yeah, and then you come automatically to construction workers, farm workers. You need to take care when they're exposed to more heat, to radical climate change. You have to take care of them. Yeah. If you go to Article 11 on the Article Standard of Living, I talked already about farmers and fisherfolk. Yeah. If you go to the right to health, what does it mean for taking care of elderly in hotter becoming cities? Yeah. What type of climatization is needed? Immediately care, long-term care. How do we deal with, let's say, for example, the whole issue of land rights? Yeah. I talked about this Pakistan shoot just as an example, yeah, but more than half of these people don't have any registered land title, yeah. So where do they be resettled? Who will pay for them? What are their legal titles for this? Yeah, that's essentially questions for the realization of these economic, social, cultural rights. So I don't say we have answered everything in the text, but we are giving guidance to this, yeah. And maybe this is also something where we can together look at these issues, yeah, where we really take such a guidebook which goes into the details of implementing each of these rights and then think about how this can be applied much more practically in court decisions or maybe by reports you are doing. I think this type of collaboration is not needed. Don't think we need 15 more legal norms or recognitions of norms. We need to go into this implementation road. Yeah. One thing is, the last is we have also one chapter which deals with particularly vulnerable groups like women, pastoralists, children. Yeah, we had these children's consultations. So this is also, you can find in this, and we have at the end the text dealing with remedies, yeah, because that's also important. And it's opening also the door for new remedies, maybe, particularly in this international dimension. I have to stop, my time has elapsed. I wanted to give you a certain taste, and I would be very glad to get feedback from you. And we are very open as a committee also to collaborate with all of the institutions, yeah, to further work on this. Thanks a lot.
Thank you very much, Michael. It's definitely fascinating. We could discuss hours, particularly, and I think it's super important to have this general comment and guidance on the various important key concepts which I hope we can discuss later on, but we'll continue with our panelists. We have His Excellency Bon Tai-son. You are the chairperson of the ASEAN Intergovernmental Commission on Human Rights, right? We heard you earlier. So the ASEAN Declaration on the Right to a Safe, Clean, Sustainable Environment is the region, if I'm not mistaken, the region's first ever policy instrument on environmental rights. So we all suspect there are high expectations about this in the region. So can you tell us a little bit more about this instrument and eventually, given that if it's true that it's the first in the region, how can international and other regional experiences be of help, right? As you finalize, complete the declaration, but also get to implementing it. Thank you very much. Over to you.
Thank you very much, Madam Chair, and thank you very much for the questions. I will share my intervention and then directly answer the question, if I'm allowed to do that.
Sure.
The ASEAN Human Rights Declaration actually had already recognized the right to a safe, clean, and sustainable environment in 2012. So actually, the UDHR, the ICACR does not have it, but in 2012, ASEAN had already recognized it. So the Commission since 2014 has been pursuing this integration of rights-based approach to environmental governance for some time. And then in 2022, the Commission initiated the drafting of environmental human rights framework that has now matured into a concrete instrument. And this year, under ASEAN's inclusivity and sustainability agenda, OHCHR under Malaysia's leadership has now concluded negotiations on the ASEAN Declaration on the Right to a Safe, Clean, Healthy, Sustainable Environment. It advances a forward-looking interpretation of Article 28F. It is the second human rights declaration in ASEAN, the first being the ASEAN Human Rights Declaration. And although it is soft law, it is, as you mentioned, Madam Chair, a policy document, policy instrument on environmental rights. The declaration is particularly significant from a Global South perspective. It, for the first time, centers justice and equity by aligning substantive rights, including clean air and water, healthy ecosystems and biodiversity, non-toxic environment, safe climate, and healthy, sustainable produced food with procedural rights, access to information, public participation, access to remedy, with the enabling civic space necessary for their exercise. Freedom of opinion, expression, association, protection of human rights defenders, and inclusion of persons in vulnerable and marginalized situations, including local and indigenous communities. The declaration also points to states as duty bearers having obligations to respect, protect, and fulfill the rights of people and communities. And we attempt to ground some sort of a model in participation, transparency, and effective access to justice, while embedding gender responsive and intergenerational justice. Reaching consensus across ASEAN has been demanding, and we have taken a very pragmatic pathway as the work has continued for the past 3 years. We need this to allow further entry points into operationalizing a plan of action for ASEAN. ASEAN's approach in incrementalism by looking at very contested human rights norms is evident through this declaration. I want to highlight very specifically as well, Madam Chair, for this meeting, that unfortunately the discourse on climate change and environmental degradation continues to be shaped and dominated by actors in the global north, and sometimes sidelining the lived realities and voices of the global south. States in the global south, including in ASEAN, in contrast, we endure disproportionate and sometimes excessive burdens, negative impacts from rising sea levels, extractive activities, biodiversity destruction, and pollution. Our region also faces severe environmental threats from extreme heat, intensifying storms, coastal erosion, and ecosystem decline, despite contributing far less to cumulative greenhouse gas emissions. Some of these challenges are magnified by the limited institutional capacities and fiscal resources available to meet the needs of our people compared to those of wealthier nations. Centuries of colonial resource extraction and consumption, exploitative trade regimes, and ongoing waste exploitation has deepened structural inequalities between the North and the South. But looking ahead, this declaration is set to be adopted at the 47th ASEAN Summit in October 2025 in Kuala Lumpur. And should it be adopted, it will constitute only the second ASEAN Human Rights Instrument since the OHCHR, making it a milestone for our region and offering an ASEAN-led, ASEAN-owned contribution to environmental rights in the global south. We have completed the 5-year work plan, and we are aligning our work on environmental rights through the ASEAN 2045, our shared future vision. We have cross-cutting priorities that includes environmental rights and climate action, business and human rights and new technologies, and human rights in situations of conflict. So this declaration would allow ASEAN organs and sectorial bodies and member states, as well as civil societies and private actors, to develop pathways and good practices that would embed a human rights-based approach in these emerging areas. Finally, I want to emphasize the prevention mandate of regional human rights mechanisms. Beyond promotion and protection, the mechanisms that we are in also through soft law instruments like this declaration can be used to prevent violations and respond promptly to emerging crises. The declaration hopefully will allow more victim-centered approaches to climate-related harms, including referral mechanisms and reparations frameworks. Taken together, we seek to ensure that the declaration does not remain aspirational, but rather advances a global South model of environmental rights protection that is coherent and effective. I want to here respond to specifically to the question. Of course, in different regions, we have different practices and different approaches to how our regions protect and promote human rights. But I think what we wanted to ensure through the declaration is that we not fall below universal global international standards. The thing about environmental rights, the right to peace and the right to development, which are three added value rights in the ASEAN Human Rights Declaration, that's not found in the UDHR or the ICCPR or the ICSR, are things that we value a lot and we place much emphasis on. The regional approaches that ASEAN has taken, of course, has been mentioned and critiqued. But we, in the Commission, depending on how we approach these issues, still want to ensure that our regional mechanism, while having our regional diversity, it still has a baseline that can refer to. And as I mentioned, Article 28F 2012 was signed by the leaders even before the General Assembly resolution and the HRC resolution. Thank you, Madam Chair.
Thank you indeed. ASEAN has been precursor of the recognition and the international level, and I think it's very important also to highlight the specificity of every regional instrument and mechanism. For example, what you said about the prevention mandate that the Commission has and how you are thinking of using also the declaration as part of having to prevent certain human rights violations deriving from environmental issues. So thank you very much, and we'll continue discussing. I think what you raised in relation to the global north, the global south, goes back maybe to what Michael was saying about how do we interpret the obligation of state to international cooperation, in this regard, and in the area of right to healthy environment. So very, very super interesting. But let me continue with Milagros. Milagros, we heard you this morning. You are a legal advisor to the Inter-American Court on Human Rights. The court has been also, discussing, has been at the forefront of judicial innovation since 2017, because there was an advisory opinion of the court already back in those days that recognized the right to a healthy environment as a justiciable and autonomous right. And more recently, we had another advisory opinion this year, right, on climate change. So maybe you can describe to us this jurisprudential evolution that the court has given to the right to healthy environment, and also the lessons that the court has drawn so far, because I think that could be useful to all of us, international and regional mechanism. Thank you. Over to you.
Of course. Thank you very much. It is a privilege to take the floor on behalf of the Inter-American Court of Human Rights. Our contribution to this panel deals on nearly 2 decades of jurisprudential development, during which the court has moved from implicit environmental consideration to a fully articulated doctrine on the right to a clean, healthy, and sustainable environment. To explain these trajectories, and I know it's in Spanish, but sorry about that, but to explain it and just focus on the numbers there, I will rely on an internal conceptual structure that is useful, and it describes the development of this case law in 4 phases. Which I metaphorically frame as planting, germination, growth, and fruit. These stages reflect the way in which the court has built legal standard over time, moving from early case law based on property and culture through the formal recognition of environmental rights into their application in judgment, and finally their expansion in the face of climate change. So let's begin with the first phase, that will be planting. You can see it there. And that first stage refers to the period during which the Inter-American Court did not yet recognize the right to a healthy environment as an autonomous right, but nonetheless address environmental harms as part of other convention rights, the American Convention I'm referring to, most notably the right to property, which is held in Article 21, and indirectly the right to life, personal integrity, and cultural identity. So this jurisprudential seed was first planted in the context of indigenous people rights. In these early cases, the court established that access to ancestral land and natural resources is essential to the survival and dignity of indigenous people. And although the focus was on territorial rights, the reasoning gradually began to integrate environmental considerations, especially regarding the protection of the environment itself and the substantial use of natural resources. There are two landmark cases, which are called Yaque Axa against Paraguay and Saramaca versus Suriname from 2005 and 2007 that resonate with this reasoning. And they contain key principal concepts such as property rights that encompass natural resources access, environmental harm may violate human rights, and states have a duty to prevent such harm, especially in indigenous territory. So that will be the first phase. And then we have the second stage, which is the hermination. It marks a turning point in the court's jurisprudence, where there is the explicit recognition of the right to a healthy environment as an autonomous, enforceable right under the American Convention of Human Rights. This recognition came with Advisory Opinion number 23, issued in 2017, as it was already mentioned, in response to a request submitted by Colombia regarding the obligation of a state in the context of environmental protection and human rights. So in this opinion, the court formally affirmed that the right to a healthy environment is protected under Article 26 of the American Convention and Article 11 of the Protocol of San Salvador. And the court emphasized several obligations, core legal obligations, which are the prevention, precaution, and cooperation. I will not expand on them, but I would like to address the fact that the prevention obligations are related to a state that must adopt legislative, administrative, and policy measures to avoid environmental harms before it occurs. And we can see all the obligations that are addressed in this advisory opinion, I mean the 26th advisory opinion, then grow into the third stage, which will be the growing. It marks this transition from doctrinal recognition to direct application of the advisory opinion itself, the one that I'm just referring. So we can see the landmark case of Yaque Axa against Argentina in 2020. This was the first time the court declared a violation of Article 26 of the American Convention on the basis of environmental harm. And a second major contribution in this third phase is the judgment of La Oroya against Peru in 2023. This case concerned long-term pollution from mining activities in La Oroya, which resulted in alarming levels of lead and sulfur dioxide in the air, as well as contamination of water and soil. And the court found that Peru has failed to regulate, supervise, and enforce environmental norms, basically the prevention obligation that was developed in the advisory opinion, and thereby it violated the right to a healthy environment under Article 26. We can also illustrate this reasoning in a last case, which is Pueblo Uva against Colombia of also 2023, which addressed, among other issues, the improper granting of environmental license for oil exploration on indigenous territory. So we see in these three stages how everything started with the lack of recognition, then we have an advisory opinion that developed the right to a healthy environment, and how the court has applied those obligations into specific jurisprudence, and that leads us to the last stage, which will be the fruits of what's happening, that it represents the expansion of the court's environmental doctrine in the global arena of climate change. So in 2023, Colombia and Chile submitted a request for an advisory opinion on the climate emergency. Now, not all the courts have this faculty of executing advisory opinion. We can receive said opinions from states that ask the court what are the state obligations on a specific right. That's what happened here regarding climate change. And we also received amicus from anyone that would like to be part of the proceeding. That means not only states that are under the convention, but civil society, an individual that wants to address the court, and that's the reason why before notifying the advisory opinion, we received more than 300 amicus that were heard and reviewed before said opinion was notified just recently. So the court, in this opinion, characterized the climate emergency as the convergence of urgency, severity, and complexity, and it clarified that the state are under binding obligation not only to mitigate and adapt, but also to integrate human rights into climate governance. There are several key aspects. We can talk about them after this panel, but basically it addressed the nature as a right holder, the right to a healthy climate, environmental rights as OHCHR norms, among other obligations that for sure we will see develop in jurisprudence in the years to come. So thank you very much for your time. I think I'm almost there with this explanation, but thank you.
Thank you very much, Milagros. Again, very super interesting. I see how the court seems to be a step ahead. And it would be interesting maybe in the discussion also to look at how, you know, the third phrase you put as growing direct application of the advisory opinion. How do we get to that for the ICJ, for example, opinion and the direct application? How do we monitor that? That would be interesting. And I'm also glad to hear, you know, we have specificities of every regional mechanism and instrument, but also similarities, the prevention mandate that you were talking about for the ASEAN, but also for the court. But let's continue and go back to all this topic during the debate. Sebastian, you are senior attorney at the Center for International Environmental Law. The center has used the power of law to protect the environment and ensure a just and sustainable society. So how has this work changed with the recognition of the right to a healthy environment? And how your organization that obviously has long-standing experience in this area, how has it supported the international regional mechanism and then other regional, national, civil society monitoring the implementation of this right? Over to you.
Thank you very much. And I'm honored to be on this panel. I find it difficult to follow actually all the points already made because the discussion was so dense. Let me try, and I would like to focus on the need for universal and unequivocal recognition of the rights to a clean, healthy, and sustainable environment in 2025, including by all regional human rights framework. The need for further developments in relation to the legal standards associated with states' obligation related to the right to a healthy environment, in particular around key themes such as the duty to regulate private actors, the need for effective remedies, and the importance of defending civic space and understanding states' obligation in that context. And finally, I'll conclude with a brief, some suggestions maybe in terms of the important roles for this forum and also other exchanges between sub-regional, regional, or international human rights institutions and frameworks. We've discussed the great progress that has been achieved over the last 2 or 3 years, including in this particular building. But also, as the special rapporteur reminded us, this is very much just a capstone building over decades of work at the regional and national level. And we've heard again about the leadership of some of the regional bodies. At the same time, I would really like to bring us back to the point of urgency. Sometimes we tend to congratulate ourselves for all of the progresses that we managed to achieve after years of painful negotiations, but it's important also to really take stock of the fact that we are still in an accelerating planetary crisis. There is an increasing number of communities that are threatened by the various the different components of the planetary crisis. And we also have the commission of genocide and atrocity crimes that systematically deny entire populations of the enjoyment of these and other human rights. A worrying counter-trend also to the recognition of a right to a healthy environment is what we observed across continents, the acceleration of a deregulation of private actors that runs in direct contradiction with states' obligation when it comes to regulating extractive and polluting industries and ensuring that the rights of communities and of individuals come first and not the profits of private companies. At the same time, we have this ray of hope coming this summer. Not only do we have this very strong International Court of Justice advisory opinion, very also strongly argued based on a very inclusive process to which more than 100 states participated. But this advisory opinion, perhaps unexpectedly, was also endorsed by 14 judges with no abstention or judge actually stepping aside this consensus. And so this gives us the strongest framework possible for us to actually build upon. And that's probably a gift to our generation of lawyers and legal practitioners, but also now it's a great responsibility for us to build upon. We also have all of those recent developments. Michael mentioned CESCA General Comment 27 and its double combination in terms of its recognition of a right to a healthy environment as autonomous, but also a right that is inherent or like essential to the protection of other rights protected by the covenants. This very much also echoes what the Committee on the Rights of Children, for instance, emphasized in its General Comment 26 in 2023. And some of the concepts that are laid out there, including maximum available resources, progressive realization, duty to cooperate, but also heightened obligations of states, something on to specific population, something that the CRC also very specifically emphasized. Those are essential to lay out legal certainty in terms of what are the legal standards that states must uphold. So we are at this crossroad, and civil society is very much looking at states and judicial institutions to help us move forward. Before I discuss the different points that I mentioned in my introduction, let me just come back to the importance of unequivocal recognition. Regional human rights systems have a critical role in giving concrete content to the rights and aligning standards. But for us to be able to see this progress, it is essential that all regions, including Europe, take a decisive step forward to recognize the right to clean, healthy, and sustainable environments through legally binding standards and instruments, so that this right is considered as a right that is to be protected on par with any other human rights. Ms. Muzio stressed this morning that owing to the universalism of human rights, universal effort is required. And so we are very much laying our expectations, hopes, and hopeful impatience on European states to take a step forward. In May 2025, the members of the Council of Europe made the decision to decide as soon as possible on the opportunity to launch negotiations towards a legally binding instrument on the right to a healthy environment. Hopefully, the exchange of good practices, lessons learned that we're hearing today can also give us confidence that indeed it is useful and critical and necessary to actually move forward on the basis of unequivocal recognition of these particular rights. But recognition is only the first step. The real test is whether we can build a normative scaffolding to ensure that remedies are available when this right is violated. And here, regional and sub-regional bodies are very much the point of convergence where these questions can be addressed with greater clarity. This is where the rubber hits the road when it comes to communities seeing their rights violated and seeking remedies. So in terms of the importance for us to see additional substantive legal standards fleshed out in terms of states' obligations related to the right to a healthy environment, I'd like to come back to these three priorities. First, the importance of re-emphasizing the right and the duty of states to regulate private actors. The deregulation or the absence, the failure of states to regulate private actors and businesses effectively is the root cause, to a large extent, of the triple planetary crisis that we are going through. And this failure to regulate adequately goes in direct contradiction with states' obligations to protect the right to a healthy environment from the threats that are caused by other actors. We also see that we have to embrace a transition that we'll be discussing tomorrow, that will require to rethink our economic system, our social relations. And this offers an opportunity for us to consider how to recenter our economy on the needs and the imperative to protect the right to a healthy environment, and how to avoid mistakes that have been committed in the past, in particular in relation to post-colonial abuses or the role of the extractive industry in contributing to harms of communities most vulnerable. We also need to see regional institutions step forward in helping states address the frivolous claims brought forth by foreign investors that have a chilling effect in terms of how governments can regulate environmental and social policies. And so we hope that regional and sub-regional bodies can also help us understand what are the limits to be put to investor-state dispute settlement. Second, it's essential to see what constitutes effective remedy and what does it involve in practice as more and more communities are facing already today the impacts of a triple planetary crisis. And in relation to this, we've seen several regional bodies having already made great contribution in unpacking what this right to a healthy environment or what associated obligations mean in practice in the context of environmental threats. The La Oroya case versus Peru was already mentioned. That's a great opportunity, a great example of how actually regional bodies can contribute to further elaborating those norms. In Europe, while we don't have yet the right to a clean, healthy, and sustainable environment recognized in a legally binding manner, we do see the European Court of Human Rights further articulating specific procedures and modalities to ensure that victims of environmental harms can see proper remedy. And I would just point to the recent Canavacciolo and others versus Italy case where the court actually decided to trigger its pilot judgment procedure, laying out very specific procedural requirements on what the state of Italy must put in place in order to remedy to the harm experienced by many in the context of this particular case. And then in relation to environmental democracy, it is essential to continue this focus that has been mentioned by many others on the protection of the civic space and different facets of the civic space, the shrinking of civic space that we experience currently. There's been great emphasis already on the importance of protecting environmental human rights defenders, and I know that we'll be discussing this further, but I would also like to acknowledge and highlight the linkages between the protection of the civic space and the role of business actors, for instance, in relation to challenges to access information in the context of proprietary information that is essential to assess environmental and health impacts, the importance of countering disinformation and the corporate capture of the public debate. Finally, in terms of cooperation across institutions, I really like to build upon what was said just previously, to call upon the institutions that are here in this room to share their practices, their experiences in terms of understanding and reviewing what are the implications of the legal standards that are contained in the different advisory opinions that have just been delivered and that will be delivered very soon by the African Court of Human Rights when it comes to states' obligations in the context of climate change. There is so much that can be built upon, and I think the sharing of good practices among sub-regional and regional bodies will just help accelerate the integration of these legal standards and the cross-fertilization across different mechanisms. I must also really welcome and congratulate some of the regional bodies that have had such inclusive processes, the Inter-American Court of Human Rights certainly, and we are very much looking forward to participating more in the advisory proceedings by the African Court of Human Rights. But this ability to really have this global debate, including states, but also academic experts, human rights experts, civil society, indigenous peoples, to help input into the court's consideration of the scope of states' obligation. That's an essential part of actually making progress in relation to the effective protection of the right to a healthy environment. One that is not limited to slogan, but that is very helpful for communities. And finally, just to conclude with this, exchanging good practices and also seeking out proactively the experience of other regional and sub-regional bodies when it comes to the concrete legal standards that are associated to the right to a healthy environment. This is probably something that this particular forum, but also all of the informal exchanges that have been described so far, could really help accelerate. Thank you.
Thank you very much, Sebastian. Again, there is quite a lot of recommendation, suggestion. Thank you so much. So I think we've exhausted the list of panelists, so we can open the floor for discussion, additional suggestion, comments, inputs. I would hope that our panelists has given a lot of food for thought. There are a number of topics that have run across all the different intervention. Well, one of which I can think of is how, for example, can international regional mechanisms come together to address the regulation of private actors, for example, right? How do we do that with the existing framework and mechanism that we have? I think that could be an interest, and each of the mechanisms from their own standpoint, from their own mandate point of view, but come together to address this. The other issues that was also that came out in a number of interventions is the issues of remedies, how to ensure a right to effective remedy in this context and vis-a-vis private actors as well. So who wants to take the floor? Who would like to make an intervention? I know there are many experts in the room. I can see them, but any comments, any questions that you have for our panelists? Nobody? Yes, Michael, you are allowed, of course. Otherwise, I have one question my first question for you would be maybe you can give us, before we go and read the general comment, how has the committee addressed the issue of extraterritorial obligation relating to business and private actors, for example? We can start with that, and you have other questions maybe. Thank you.
Yeah, thanks. Well, the committee has made an own general comment number 24 on business and human rights, economic, social, cultural human rights, which is already very explicit on, let's say, the extraterritorial dimension of this. Yeah, and our text yet is reiterating this. Yeah, but it's also making sure it's a state obligation to regulate business. Yeah, business at home, but also business abroad, acting abroad. And also then all the relevant services for investment, which are financial flows, technical support, and all these licenses which belong to this. So this is captures in the text, and I think it's a very important element. But it has something which governments have to guarantee, or when they are maybe too weak in the concrete specific terms, we need to find ways how this can be strengthened by international cooperation and assistance. I think that is important, that the institutions involved in this, who are also running or giving money, for example, for this type of investments, are also very alert to this. I think that is extremely important. I want to say, among the things you have mentioned, when we talk about remedy, it's already always late. Yeah. We talk also about the issue of prevention. Yeah. And we realize more and more in our committee that this is a key element of this also. Yeah. Because where does it happen? For example, in regional planning or city planning or urban planning or rural planning, that you have to make decisions for what is the land use, either for mining, for smallholder farmers, how to protect groundwater, is it used for a sewage waste dump or so. So you have to make these type of decisions, and they require a lot of prevention, thinking about how much in let's say governmental planning, and I would like to highlight also that this is a very important element, because if you do or react too late when things has happened, it's often very difficult. And to find a modus operandi which leads much more to careful planning, impact assessments, as you were highlighting, and doing this in the right moment and doing this particularly participatory, so that people who are potentially affected has really voice to be heard. I think that would change a lot, because that would also influence investment decisions. And partially also, I know this for business, they don't want to be acting totally against the local constituencies. So they would listen to this. So I think these processes are extremely important to mention. It's not talking about against remedies. It's talking about that the prevention or the care at the beginning and the regional integrated planning are tools which are extremely important, and they need to be opened up. They need to be made participatory, and they need to be accessible for those like human rights defenders or not being threatened, civic space. Sebastian was mentioning, I think that is an important component to this.
Thank you, Michael. Did you have a question for some of the other panelists? Otherwise, Anyone else?
I could address that question about companies.
Yes, okay, yes, okay, Milagros, go ahead.
So just continue with the dialogue about how private actors are involved in this predicament and the remedies. I would like to emphasize again the case of La Roya versus Peru because I think it's an important and valid one. So in the court judgment, specifically in paragraph 114, the court points out that companies, it's the first time that the court does this, that it points out that companies are primarily responsible for acting responsibly in the activities they carry out, since their active participation is fundamental to ensure respect for and the enforcement of human rights. And then it dives in the fact that business should adopt at their own expense preventive measures to protect the human rights of their workers, as well as the measures aimed to prevent their activities from having a negative impact on the communities or on the environment in which they operate. So based on this reasoning, one of the reparations that are included in this particular judgment is the fact that the state companies are obliged, and particularly companies that execute mining activities, because this is a case about mining. Title holders of mining concessions are the ones who need to guarantee human rights, the human rights, and the state is obliged to supervise and to pose sanctions of those title holders. This may sound as a regular reparation, but it's the first time that the Inter-American Court addressed the obligation of the state in regards to a company that could execute mining or any other extractive activity. So the first case in which the Inter-American Court developed the relationship between companies' human rights was in Oliveira against Peru. It's not that I'm Peruvian and the only cases are from Peru, but this just happened to be a coincidence. So the first case was Oliveira against Peru. It has nothing to do with the environment, the case itself, but it's the first time that the court addresses this topic. And then it has the opportunity to also explain it in the language of environmental rights. So that's the reason why I would like to emphasize how the court has not only developed a reasoning, but also a reparation that is directly connected with how companies should develop their activity. Now, we are not in this judgment is from 2023, so we are still within the scope of the years in which the state needs to fulfill the reparations. We don't know how that will be implemented just yet, but we have at least that framework. And we will see in the following years how these evolve again, and now with the new advisory opinion on climate change. So it's interesting to develop and dive into this topic.
Yeah, thank you very much, Astrid.
Thank you. And thank you, also Milagros, for mentioning a few cases. What I wanted to emphasize is one key obligation of states is the obligation to prevent environmental harm, including to the climate system. This has been already developed under international human rights law, and we have a very important conclusion and clarification from the International Court of Justice from the advisory opinion. I also want to highlight that it's an obligation that the court has mentioned that is erga omnes. So it's not only linked to treaties that states have ratified. Even if states do not ratify or decide to get out of a treaty, states are and have the obligation under international law, and this is customary international law, to prevent significant environmental harm, including to the climate system. And we also know that when we talk about the right to a healthy environment, as we have heard, we also talk about clean air, healthy and sustainable food, healthy water, non-toxic environment, healthy ecosystems and biodiversity, and safe climate. Just as a reminder that we're not only talking about climate. One of the key aspects also that I wanted to highlight is that we're talking about present and future generations. And again, this is something that international advisory opinions and regional courts have referred to, and it's important. And there is, and I guess that the general comment haven't read it, I will, but I guess that the general comment also mentioned, and we in special procedures have highlighted the importance to protect present and future generation rights. Regarding the environmental impact assessments and the worrisome and the deregulation wave that I'm seeing, it's very important that we understand and use lessons from litigation. As La Oroya, as we heard from the Inter-American Court on Human Rights, but also from European court cases, and in the African jurisdiction, also from Nigeria. There is a lot of litigation and also remedies that states are paying and have to pay because of the deregulation and lack of control to investors or private actors. And this is something that states can prevent with an adequate regulation and imposing, including environmental impact assessments. In La Oroya, one of the key aspects also that the court analyzed and concluded is that regressive legislation, in this case regarding standards of air quality, can be a human rights violation, and was one of the reasons why the state was declared that they were violating human rights of people in La Oroya, because a change of legislation was regressive. And so this is one of the key aspects also that it's important to have in mind. We're seeing, and with the Cannavacciolo case, for example, from the European Court of Human Rights, that there are cases that have taken decades, and fortunately and hopefully we can again, learn from those lessons, listen from environmental defenders that for decades, and even state actors have mentioned for decades, highlight situations of contamination and how those are impacting human rights, and then incorporate adequate preventive actions to do it. Just to finalize that, unfortunately, while we see this advancement in advisory opinions, we also are seeing increasing of business as usual and more instruction without the regulation. This is a key opportunity for international and regional mechanisms to prevent and to help states to comply with their obligations. Thank you.
Thank you, Astrid. Michael, you had another point.
Yeah, future generations are taken up. We had, as I told you, 5 consultations with kids, which we organized together with a Geneva-based organization, Child Rights Connect, which are doing also some of these participatory things the Child Rights Committee is regularly doing. It was for the first time that our committee did it, and it was very useful. And the first surprising thing was the kids were often not talking about future events. They were talking about actual not existing school, actual hardship they had. Yeah, so that was very much raised. Yeah, so it shows also the existing injustice are often addressed by the kids. Yeah, so there needs to be overcome. And we learned in this process they need to particularly overcome in terms of the environmental prospects. Yeah, so if you have a slow onset change of maybe the landscape because becoming dry, and you have nothing like a regular registered land title because you are women alone with kids, you will not get any compensation. Yeah, so it is extremely hard. Yeah, and I told you already, it's also the case if there is a big storm. Yeah. The Typhoon Haiyan in the Philippines were hitting 8 million people, many without any legal title. So these existing, let's say, weaknesses in the recognition of economic, social, cultural rights are really mounting to the real problems linked to economic, social, cultural rights. Yeah, so for me, prevention is partially implementing economic, social, cultural rights. Yeah, talking about secure access rights to tenure, secure rights to access to, let's say, health system, or maybe social security avenues. Because if that is not happening, both the slow onset but also the catastrophic events will hit these groups particularly difficult. They have no access to remedies at all because they have no claims. Yeah, so that is becoming very clear. It was becoming particularly clear when we were listening to kids describing their own situations. I think that's very important. So it's a mixture which is needed. Yeah? It's not only thinking about potential environmental problems, it's really also thinking about what do we have to make sure that those who are in a weak and vulnerable or marginalized situation needs to be supported to be enabled to deal with the changes which will come, and these changes will come. Yeah? So I just want to make this link. Yeah? So the discussion about future generations is always about how much do we have to safeguard the current generation, and then thinking about future generation. It goes hand in hand. Yeah? Not in order just to think about future generation and the yet poor are totally forgotten in this context. I think this to have this done carefully requires a lot of thinking about the current injustices which we have here.
Thank you, Michael. Sebastian, yes, go ahead, please.
No, I think this is a great discussion also because when we speak with states and with regulators, we get a lot of questions around how do you implement practically intergenerational justice for the human rights of future generations? Where do you set the safeguards for protections for legal standards? And I think this is exactly what regional and sub-regional bodies can really help us. And also national human rights institutions, of course, who also probably have a very important role to play in relation to the importance of taking preventive action and not just remedying harm once it has occurred. I just wanted to come back to one point that Milagros mentioned in terms of what happens after the judgment and also what can we learn from it. And I think that's another part where we can have a lot more exchange of good practices and knowledge, experiences between the different regional and sub-regional bodies. It is the execution of judgments, because we know that some of those judgments have a very important role to play in making sure that the harms impacting large segments of a population can be prevented, but this requires also political action afterwards. And we've seen across the different regions challenges in implementing some of the great judgments and decisions by judicial authorities. In Europe, we still have an ongoing conversations, for instance, in relation to the judgment that was mentioned this morning, Verein Klimasenioren in Schweiz, against Switzerland, where there is this discussion on exactly what it is that we can demand from the national government. The judgment is quite clear, but then ensuring that the government actually follows, that's something that I think we will keep struggling with. And I think this exchange between the different bodies can be extremely informative, because if a judgment really lays out a great remedy, but it is not fully implemented, then it's actually seen as a second source of harm or injury for the community that brought the case in the first place. And for some of those judgments, it's a decade in the making, as Friedman has mentioned earlier. So I think this is something where probably a next frontier in terms of actually laying out and fulfilling states' obligations in relation to the right to a healthy environment.
Thank you. Anyone else? Yes. And then we go back to you, Michael. Elisa, please, go ahead.
Change in human rights. Thank you so much for this important and most timely panel. What I was reflecting upon also in the light of the recent general comments and of course the advisory opinions is how important and maybe challenging it can be both for treaty bodies and regional instruments and bodies to engage with a broad range of areas of science to fully protect the human right to a healthy environment. We've seen a lot of reliance on climate science in the context of the advisory opinions, but I think there are other areas of science which have been relied upon as I was skimming through the committee general comments in terms of biodiversity science. I think health science and particularly planetary health science can provide really important areas of evidence for all human rights bodies to better understand the connection between planetary challenges and crises and the lived experiences of those who are most affected by those crises. But crucially also understanding what should be the actions and how relevant action to protect human rights and advance meaningfully environmental protection can be taken. So I'm just wondering whether there may be any reflections from the panelists, either about some of the continuing challenges in engaging with the science, any ideas about how special procedures and maybe other UN human rights bodies can support that advancement, and any other reflection on the topic of the science.
Yes, thank you very much. I think that's a good point we haven't touched upon. So Michael, over to you. I don't know if you want to address this specific one and something else you had in mind.
Well, it allows me to promote another general comment. Yeah, we also made one, number 25, on science and economic, social, and cultural rights. And we as a committee has also done several statements around COVID and access to vaccines and other things. Yeah, so I think that is a very relevant one. And we see also that the factual evidence of science is a lot of challenge at the moment. Yeah, even in 80 years celebrations of the United Nations, we hear that's a hoax or whatever. So we have to be very critical. Yeah, that is extremely important. We need this evidence, but evidence is not always so clear. What is evidence? Yeah, when it comes to protection of soils, you need maybe modern evidence, but you need maybe also traditional evidence from indigenous communities or others, pastoralists. So having a fair balance in this, I think in our general comment on 25 on science, we are reflecting on this. And I think we also have taken it up in the general comment now. I think that it's very important. And I agree with you. It's extremely important to have this fair access to, let's say, scientific progress. That means also for all countries. Yeah? So it's access to technology and maybe also environmentally friendly technology. Yeah, that is extremely important in that context because that is often missing, or maybe the new business to some degrees. One last point I wanted to say, which I had forgotten, is that even the response to environmental emergencies or challenges like climate change itself can be harmful to the enjoyment of economic, social, cultural rights. Yeah, so we have enough cases where carbon offsetting, for example, leads to a form of land grabbing. Also, yeah, where we went through. I had read a study recently. If you look in all the nationally determined contributions which has been presented to the climate negotiations, there's 10 billion square kilometers already registered for soil-based or land-based carbon sequestration. 10 billion would be the size of the United States. Yeah? It would be 1/3 of Africa. But where is all this land? Yeah, and all this land is not unused. We don't have that. Yeah, it's all land where people are living who don't have a title, maybe. Yeah, so there is a big problem. Now we have to think about this when we find for solution. We look also for scientific solutions. I just want to flag this. We have also addressed this in one or two paragraphs in our general comment. I think it's an important issue we have to think about. Yeah, like all other investments, needs to be scrutinized with an environmental impact assessment. Also, maybe those we need, or the technology inventions we need to combat climate change. So I think that is extremely important. That needs to be science tested, evidence based, but it needs also to be environmental and social impact assessed in a way, yeah, in order to make sure that this doesn't, but really support those who are looking for an easy solution, but not those who are maybe particularly marginalized. Yeah, thanks.
Just right.
Thank you. Yes.
Just,
May
yeah, wait.
Astrid, over to you.
Sorry, yeah, because I already talked, but thank you. Thank you very much, Special Rapporteur, for that question and that comment. So the first thing that I wanted to mention is that all advisory opinions that we have seen already have highlighted the obligation of states to make decisions based on the best available science. And even the Inter-American Court on Human Rights mentioned the right to have access to science as well. It's actually in the chart also in the Americas. So that's an essential part of the element that it's very important to make sure that it's included. The second point that I wanted to mention is that, of course, although we would love to be able to, as lawyers and from the human rights perspective, to solve everything, we do not have all the answers. And so it's very important when we talk about climate and environment to address these issues from a multidisciplinary approach. And the cases that we have mentioned, and not as a special rapporteur, as in my other life as an attorney, I had the privilege to actually represent victims in the La Oroya case. And for 2 decades almost, people using science were trying to convince the government about the violations that they were suffering. And it was very difficult to advance solutions because of the influence, unfortunately, of the industry. And so it's very important to identify from states' perspectives that science can help them to implement their obligations. And it's everywhere as well. Today, we have also the importance of science in order to counterbalance misinformation, as you were saying as well. We're hearing even at the UN General Assembly about how climate change is the biggest con or something, but we have to include that the science perspective to be able to understand also and implement solutions, including inequality. Not only in climate, but also on the human right to healthy environment. Inequality is in the center also of many of these violations. So it's very important to have, to incorporate science. And when I talk about science, it's both from the Western perspective, but also indigenous and ancestral science is absolutely key. And there are many solutions there that we need to advance. So not only from the technology perspective, but also from this traditional indigenous perspective, there are many scientific-based solutions. Thank you.
Thank you, Astrid. Please.
Thank you, Madam Chair. Just thank you for those two questions. Just responding in 3 points. One, the problem that I think the big challenge we face in Southeast Asia and ASEAN in dealing with climate change and environmental issues to get the businesses on board. So when we talk about states and state obligations and state responsibility, I think there are some norms that have been accepted, but the extent of norms and extent of duty of non-state actors and businesses are still quite heavily contested, and I think requires more work. That's the first point. The second point is the issue of what we have been doing. We have been advancing, or we are looking to advance the issue of the right to science next year, and particularly on responding to climate change. But last year in 2024, and now developing what we feel should be something that we can adopt as a baseline. We've been working on the issue of indigenous and traditional knowledge in adapting and responding to climate change, and that was one the point that Astrid has made. But I think the challenge for us is that we have so much indigenous and traditional knowledge in our region. It's been quite difficult, or it's not, or there are no, I don't think we have seen tasks work being undertaken to dictionarize that kind of traditional indigenous knowledge, where it is seen in on the same level, on par with science. So I think on the issue of the right to science, that becomes quite relevant. And then finally, within our region as well, we find that the environmental experts work in silos from the human rights experts. So when we talk about the right to science, and we talk about climate change, and we talk about environmental rights, it's been really difficult to just get across the table, because we are represented by different bodies. For us, we are not environmental experts. We talk mainly about human rights, but we need to reach over to the other side, another body, the ASEAN senior officials on environment, to try and advocate for a more rights-based approach. And that's why for us, even a very simple document or instrument that, though not legally binding, allows us to, in that sense, marry the mandates of both bodies within our region. Thank you.
Thank you very much. Sebastián Milagros. Yeah.
Okay, thank you. Just to emphasize that in its advisory opinion as well on climate change, the Inter-American Court recognized not only the relevance of conventional or academic science, particularly that produced by international organizations and the global scientific community, but also the validity and contribution of other forms of knowledge, most notably that traditional knowledge system of indigenous and tribal people. So the court has already emphasized in its advisory opinion the importance of this ancestral knowledge in connection with measures to protect biodiversity and the ecosystem, particularly those that have a crucial function in regulating the climate system and the planet's natural cycles. So specifically, the court indicates in its reasoning the essential role in the preservation and sustainable management of this ecosystem it's because of the ancestral knowledge that indigenous people have. And I think that it goes with the point that has already been mentioned, but it's interesting to emphasize the fact that the Inter-American Court in this advisory opinion introduced the importance of both the best science in the Occidental terms, but also the ancestral knowledge of indigenous peoples. Again, this is an advisory opinion and we don't have a case just yet, so we will see later on how it is displayed in the jurisprudence, but so far it's quite important to emphasize this reasoning that the court has already indicated.
Yeah.
Thank you.
Thank you. Yes.
No, I'd like to thank the Special Rapporteur for this very important question, because this goes back to the important role that human rights institutions and frameworks must play in preventing harms and not only providing remedies, and making sure that the regulation of private actors or research is adequate so that we do not deploy or introduce new technologies that could be harmful and will create more harms than the solutions that they provide. And in relation to this, I'd like to point to the other two advisory opinions on climate change, but also mention specifically the link between human rights obligation and the precautionary principle. The ICJ reaffirms the conclusion in its advisory opinion, which reaffirms the conclusion of EPLAWS, that states that the precautionary approach is also an integral part of the general obligation of due diligence under the duty to prevent significant harm to the environment. And so hopefully this is also an area where we can have very clear linkages between human rights obligations of states to take preventive action and the environmental law principles of precautionary action. I'd like also to invite people in the room to actually, or to point you to the very useful report published in 2023 by the UN Human Rights Council's Advisory Committee, and that addressed the impact of new technologies for climate protection on the enjoyment of human rights. That also provides a lot of very useful information that can be helpful, hopefully, for future consideration in the context of climate change, but also even beyond, in relation to just generally the application of the precautionary principle and related states obligation in the context of new technologies that are supposed to help us tackle the triple planetary crisis.
Thank you very much. I see there's still no one else from the floor, so we can possibly conclude this first panel of the afternoon, right? So we have a few minutes for the panelists to change. It's been really a rich discussion and really fascinating discussion to me. I think there are quite a lot of points that could be turned into practical recommendations. For example, how do we share these lessons learned and good practices? You know, there is a lot of litigation out there, as Astrid said. Okay, how do we access that, and how can everybody use it in a way to advance in its own institutions and regions? The issue of prevention has come quite loud and clear. So what could be the role of cooperating between the regional and international mechanisms, this prevention role? The issue of businesses, we haven't gone into very much depth, but I mean, there's much more that can be said on how to address the role of the regulation of by private actors. On the litigation, we haven't heard, maybe it would be interesting how that litigation at the international level goes in relation to the right to a healthy environment. I mean, there's a lot of litigation in the Americas, but what about at the international level? The treaty bodies have also that role, right, of individual adjudication of individual cases. So maybe in the next part of the afternoon we can see if this comes up. So thank you very much again. Thanks to the public. I hope this sparked some food for thought for at least the next panel of this afternoon. So we'll just have a few minutes to change panelists, and we'll continue the discussion anyway. Thank you.
Thank you.
Thank you very much.
Thank you. Yeah, we could continue talking. Discussions that are so long. And we're talking and working forever together.
Yeah. Yeah.
Well, one of the things.
Thank you.
Let's do
Today into
Yes.
no. Looking forward to the
Yeah.
Our communication. Every meeting. Exactly.
Moderation, we will see each other tomorrow. So,
Okay, thank you very much. Thank you for coming. Yes.
Identity. Yeah.
Oh, yes.
The what? What did you?
His pin.
I'm
I saw it. When you were here. Federica, is this yours?
Yeah, this is my.
I don't
Madam
want to.
Stay. I'm
Okay,
going
but
for
I
a
just
technical-
don't. Yeah.
Okay, this is so the other. Tengo una parte, pero solo tengo nada. ¿Y se lo dieron o no? Sí, es esto. Pero
All right, here we go. Welcome back for the last panel of this afternoon. Again, we continue the discussion around the existing regional international mechanism and frameworks on the right to a healthy environment with a different set of panelists to hear from them and from their regional perspective as well. So first of all, I'm very honored to welcome Her Excellency Dr. Salma Rashid, permanent representative of the Maldives to the UN in Geneva. So Her Excellency, the Human Rights Council recognized the right to a healthy environment in 2021. So if you, in your intervention, you can tell us what have been the discussion in the council since then, how this discussion have evolved, and what also the council has said, maybe in terms of the cooperation between the regional and the international mechanism in order to implement this right. Thank you. Yes, over to you. 7 minutes, yeah.
Excellencies, colleagues, allow me to begin by expressing my appreciation to the Office of the High Commissioner for Human Rights for organizing this important panel. This year's focus on the right to a clean, healthy, and sustainable environment could not be more timely. It speaks directly to one of the most defining challenges of our era and to the solutions we must urgently pursue. In recent years, the Human Rights Council and the General Assembly came together to take a historic step, a step that affirmed clearly and unequivocally that every person in every corner of the world has the right to live in a clean, healthy, and sustainable environment. This recognition did not happen overnight. It was the result of decades of advocacy, of relentless courage, and of a steadfast belief shared by many. A belief that our planet and its people are inseparable, and that to protect one means to safeguard the other. It was with this conviction that the Maldives proudly championed Human Rights Council Resolution 48/13 and General Assembly Resolution 76/300. Excellencies, colleagues, these solutions matter. They carry an enormous normative value. They crystallize the meaning of this right, both in its substantive elements and in its procedural elements alike. They go far in strengthening the link between human rights and environmental law, while placing the right to a clean, healthy, and sustainable environment within the broader framework of the 2030 Agenda for Sustainable Development. Since their adoption, the impact has been tangible. Member states, national human rights institutions, and the civil society have invoked these resolutions in advocacy and action. Courts are drawing on them in their judgments. Legislatures are embedding them in the constitutions and laws, placing environmental rights at the very heart of governance. And they are increasingly reflected in international agreements. From the Sharm el-Sheikh implementation plan on climate action to the Kunming-Montreal Global Biodiversity Framework. A notable step forward has been the creation of the mandate of the Special Rapporteur on the right to a clean, healthy, and sustainable environment. This mandate has already proven invaluable. Through reports, research, and country visits, the Special Rapporteur have clarified the scope of this right and highlighted both progress and gaps. Last year, the Maldives had the honor of hosting Dr. David R. Boyd in his capacity as the Special Rapporteur then. These developments show us that the recognitions of this right has created momentum. But we must face the reality that gaps still remain in implementation. There is a lack of coherence across institutions, both at national and global levels. Structural and institutional hurdles persist, And for small island developing states, the greatest barrier is not political will, it is capacity and fiscal space. So we must ask ourselves, how do we overcome these gaps? First, we must continue to mainstream this right across multilateral human rights machinery, especially at the United Nations. From the Universal Periodic Review to the treaty bodies, from special procedures, mandate holders to Office of High Commissioner of Human Rights, technical assistance, every mechanism has a role to play in advancing implementation. Second, regional frameworks can serve as laboratories of progress. By interpreting their instruments through the lens of this right, by building capacity, and by sharing good practices, they can inspire reform across the regions and beyond. Third, we must act to move from affirmation to action at national level. We need to mainstream this right across our legislative aspirations and our policies. We must strengthen the procedural pillars of this right by ensuring access to information, enabling public participation, and fostering environmental literacy. And above all, we need global solidarity. This right will remain out of reach for many without financing and technical partnerships. UN agencies, multilateral development banks, climate funds, and regional institutions must prioritize support for integrating human rights and environmental protection, especially for small island developing states. Without such cooperation, the implementation gap will only widen. Excellencies and colleagues, the right to a clean, healthy, and sustainable environment is a shared imperative and a collective responsibility. It is a foundation upon which we can build fair and effective responses to the climate crisis, biodiversity loss, and environmental degradation. We must solidify this foundation. We must turn the recognition into this right into universal consensus and consensus into meaningful implementation. Without a strong and coherent global framework, progress will remain fragmented, and the promise of this right will remain unfulfilled. Thank you.
Thank you very much, Ambassador, for recalling for us also the normative weight that the recognition has had on this right, and also how it has fed, the recognition, other advocacy work, international agreement. That's very important. We can go back to during the discussion to some of the points you raised, including, for example, the important point of the fiscal space of certain states and countries in order to address the planetary crisis. But let me turn to Wilson de Almeida Adao, who is you are the chairperson of the African Committee of Experts on the Rights and Welfare of the Child. So this afternoon, we haven't heard yet the African regional system perspective, right, in relation to the right to a healthy environment. So maybe you can tell us a little bit of what's happening in the on the continent in order to advance the implementation of this right. Over to you, 7 minutes. Thank you.
Thank you for giving me the floor. First of all, on behalf of the African Union, I would like to thank for this invitation and speaking about advancing the right to clean health and sustainable development. The African Charter on the Right and Welfare of the Child, ratified by 51 African states, is foundational instrument for children's rights in our continent. While there is no dedicated provision in the Charter on the right to clean, health, and sustainable environment, it is mentioned on the Charter. In this context, the right to education is under Article 11(2)(g). The Charter provides that education of the child should be directed to development of respect for the environment and natural resources. The Article 14(2)(h) on the right to health further mentions that states need to assure support for environment, sanitation, and the prevention for domestic and other accidents. Moreover, the preamble of the Charters is outlining the rationale behind the adoption of the Charter rise disasters and angers among the challenges faced by the African children that call for their protection under the Charter. Many provisions are relevant in drawing the nexus between the rights in the Charters and the right to clean, health, and sustainable environment. To mention few, Article 5, which calls for the state to assure to the maximum extent possible the survival, protection, and development of the child require clean, health, and sustainable environment for its realizations. Article 23(4) extend the protection for refugee children to children who became internally displaced due to natural disasters. In our general comment on Article 11 on the right to education, the committee provided a progressive interpretation that education should aim to strengthen and accelerate locally relevant initiatives that are proactive, responsible, and adaptive to address climate change risks and environment shocks. It also provides that climate change and environment education should aim to increase children's literacy on the country-specific environment and climate impacts. This interpretation presupposes the need to have a substantive right for every child to live in clean, healthy, and sustainable environment. Just to recall, in the last years, the theme of the year of African Union was the right to education for all African children. Furthermore, our general comments, number 5, on state partner obligation, explicitly underscore that link between the best interest of the children and the environment protections. It's not that the long-term best interest of the children call for assuring that enjoyment of the rights of future generations of children be preventing environment degradation or inappropriate exploitation of natural resources. Excellencies, ladies and gentlemen, our committee has established the working group of the rights and climate change to lead its efforts on climate change, including the right to clean, health, and sustainable environment. The working group leads development of the continental study on climate change and children's rights in Africa, which reaffirmed that the right to clean, health, and sustainable environment is not merely an aspiration goal, but a foundational element of enjoyment of all other rights. This study underscored that climate change is not distant threat, but also present-day crisis for African children. Of the 33 countries globally classified as extremely high risk, 25 are in Africa. It highlights that droughts, floods, and extreme weather events are displacing children, disrupting their education, and exacerbating vulnerability, especially for girls, children with disability, and those in marginalized communities. To address this challenge, this study calls on states to ensure climate policy and laws in children's rights laws and to prioritize adaptation efforts. It calls for disaster preparedness laws to explicitly link children's rights and climate resilience to assure comprehensive protection measures. It also calls for the meaningful participation of children in climate actions and environment-related efforts and assuring the right to justice on environment issues. The working group also extensively engages in norm setting through the adoption of resolutions and statements, including the resolution of integrating a children's rights-based approach into climate change actions, and statement during the African Day of the Food and Nutrition Security on the nexus of the right to food and climate change for children in Africa. Recognized of the gravity of the climate crisis and the disproportional impact on children in Africa, the working group has launched the campaign called 11-I, a child rights approach to climate actions in Africa, demanding urgent actions geared at child-centered adoptions and the response to the loss and damage in Africa due 1.1 degree global warming. Pertinent engagement in UN and its mechanism, I would like to highlight that our working group made a submission to the UN Special Rapporteur of Climate Change and Human Rights on the call for contributions on access to information on climate change and human rights. In these submissions, the working group underlined the need for the child-friendly information on climate change, including the right to clean, health, and sustainable environment. The working group also submitted the legal brief for consideration to ICG advisory opinion process on climate change to the African Union Commission writing and oral submission in the ICG. Moving forward, the ACWC will continue to elaborate the African Children's Charter in light on involving environment norms set at regional and global level. We remain guided by UN General Assembly recognition on the right to clean health, a sustainable environment, and the General Comment number 26 of the Committee on the Rights and Welfare of Child. We are committed to strengthen partnership on the right to clean health and sustainable environment to enhance impact and coherent standards. Thank you, Excellency, and thank you, sir.
Thank you very much. And also, thank you very much for the practical examples. For example, your working group submission to the UN Special Rapporteur call for inputs for her thematic report. I think these are very, and vice versa, because I believe some of the UN Special Rapporteur, for example, sent inputs to the call made by the African Commission on Human and People Rights that is developing a general comment on the right to a healthy environment. So these are very practical examples of the way that the various mechanisms can support each other when they try to advance interpretations and of the right to a healthy environment in their respective regional or international frameworks. But again, we can discuss that further. Let me move on to Xavier. We heard you already in the morning. You are the Special Rapporteur on Economic, Social, Cultural, and Environmental Rights and the Inter-American Commission on Human Rights. I think that this rapporteurship is as old as the advisory opinion of the Inter-American Court on the right to a healthy environment, and so has been there even before the various international level recognition of their rights. So Xavier, can you again tell us what has been a little bit the obstacles that the Inter-American Commission and your rapporteurship has faced in monitoring the implementation of this right, despite all these innovative standards and jurisprudence that the court and the commission have developed? So what would be your lessons that you can share with us and for the benefit of all the other regional and international mechanisms? Thank you. Over to you.
Thank you very much, Madam Chair. And I will do my remarks in Spanish again. La pregunta es muy apropiada. Como mencioné al finalizar mi intervención anterior, hay una brecha bastante importante en lo que es reconocimiento del derecho y las realidades nacionales, los retrocesos de protección ambiental en los distintos países, que se manifiestan de diversas maneras, desde degradación institucional a desfinanciación de las instituciones, a modificación de estándares técnicos, por ejemplo, respecto del agua, levantamiento de moratorias o prohibiciones, modificación de los regímenes de licenciamiento ambiental, múltiples tipos de modificaciones que pueden ser consideradas retrocesos. No obstante eso, en el sistema interamericano, el derecho al medio, al ambiente sano es clave, porque muy claro en el panel anterior, es un lugar central en la jurisprudencia más reciente, el motor de la ambientalización de los derechos humanos y fortalecer la fundamentación jurídica y la operacionalización de este derecho parece ser un desafío muy importante. Me voy a referir a dos caminos, a dos desafíos que están vinculados con dos caminos. El primero tiene relación con el rol que le corresponde a la Comisión Interamericana de Derechos Humanos, la RADESCA, a la Relatoría Especial sobre Derechos Económicos, Sociales, Culturales y Ambientales, en relación al sistema de peticiones y casos. Nosotros tenemos un sistema que cuenta con dos opiniones consultivas relevantes en relación al derecho al ambiente sano. Fueron reseñadas hace un momento, pero que no cuenta con tantas sentencias contenciosas en las cuales se haya responsabilizado al Estado por violar el derecho al ambiente sano. En ese sentido, uno de los desafíos que enfrenta la relatoría y en el que estamos abocados tiene relación con la elaboración de informes de fondo, utilizando las políticas de priorización de la Comisión Interamericana de Derechos Humanos, a los efectos de acelerar la posibilidad de contar con estándares interamericanos resultantes de jurisprudencia contenciosa de la Corte Interamericana de Derechos Humanos. Sentencias que van a ser muy útiles a los efectos de explicitar de forma concreta las obligaciones positivas de los estados y poder abordar la causística general que enfrenta la región en relación a esta temática específica. Tenemos en la región algunas herramientas clave que no forman parte del marco jurídico interamericano, pero que son fundamentales. La primera es el Acuerdo de Escazú, que fortalece el reconocimiento de los derechos de acceso, que fortalece la defensa de las personas defensoras del medio ambiente, cosa que es muy relevante por lo menos por dos razones. La primera, el Acuerdo de Escazú ha sido una herramienta normativa muy útil a los efectos de alcanzar a los países del Caribe, especialmente el Caribe anglófono. Alrededor de 8 o 9 países del Caribe anglófono han ratificado este tratado regional de Naciones Unidas. Algo que es envidiable desde el punto de vista de las propias normas del sistema interamericano, Convención Americana y Protocolo de San Salvador sobre derechos económicos, sociales, culturales, que no ha tenido tanto éxito entre esos países del Pacífico. Y también es especialmente relevante porque estamos hablando de la región del mundo más peligrosa para las personas defensoras del ambiente. Por lo tanto, se trata de una característica fundamental del desarrollo normativo relevante para el sistema interamericano. Además del Acuerdo de Escazú, me gustaría mencionar una situación específica que enfrentamos en el sistema interamericano, que es el carácter, llamémosle, objeto de debate que ha caracterizado el reconocimiento del derecho al ambiente sano en el marco de la jurisprudencia reciente de la Corte Interamericana de Derechos Humanos. Este reconocimiento del derecho, que parte de la interpretación de que el derecho al ambiente sano se encuentra recogido en el artículo 26 de la Convención Americana, nunca contó con votos unánimes por parte de la Corte Interamericana de Derechos Humanos. Siempre ha tenido votos disidentes, lo que da cuenta de una cierta disputa en torno a esta interpretación de la Convención Americana que posibilita y ha posibilitado la responsabilización de Estado por violación de este derecho. Un último bloque de desafíos está vinculado con la operacionalización. Creo que es necesario transitar rápidamente del reconocimiento a la operacionalización. Cuando digo esto, lo estoy hablando sobre todo desde el punto de vista de las políticas públicas nacionales. Esto implica una consolidación de la autonomía de este derecho, implica profundizar en esta función ambientalizadora en relación al conjunto de derechos humanos, vida, salud, agua, alimentación, vivienda, que implica, en definitiva, la incorporación del enfoque de derechos humanos en las políticas ambientales, en las políticas climáticas. En relación a este punto, en forma específica, el gran desafío que estamos enfrentando en este momento es la construcción de un marco jurídico interamericano, el derecho a un ambiente sano, orientado a traducir los estándares interamericanos desarrollados por la Comisión Interamericana de Derechos Humanos, por la Redesca y también por la Corte Interamericana en mandatos operativos de política pública medibles y exigibles. Ya excedí el tiempo, pero considero que esos dos son los dos grandes desafíos con los subítems que he mencionado. Muchas gracias.
Muchas gracias, Javier. Thank you very much also for reminding us of the Escazú agreement, which also is that was, as you explained, was born from specific needs and specificity of that region, but which has been let's say pretty successful, particularly in the safeguards of the work of the environmental human rights defenders. So thank you very much, and we can continue discussing later on the obstacles and how to, for example, operationalize this right in national public policies. I think that seems to be the logical next step. But let me go to the last panelist of this session, Rafael. We heard you already. So the Council of Europe, we all know, has a pretty elaborated human rights protection system, and yet we heard there is no recognition of the right to healthy environment yet, right? No standalone right, as Xavier was saying. So maybe you can tell us a little bit what are the challenges in that region in relation to this right, and also how can the Council of Europe benefit from all this wealth of experiences around in other regions at the international level. Over to you, 7 minutes, thank you.
Thank you. Thank you. Well, first of all, I think you have a bit done my job in the sense of explaining why the Council of Europe is relevant here. And yes, absolutely. I think for those of you who are less familiar, we since 1949 have in place a very strong system of human rights protection. Now, we also have a system of environment-related instruments. And it's funny because this one started developing not in 49, not in the 50s, but in the 60s. So we have an array of instruments relating to the environment. growing at the same time in parallel with a system of social rights instruments. So the European Social Charter is from that period, but are also two specific instruments. We have the Berne Convention on Wildlife and Natural Habitats, and the Florence Convention on Landscape Protection and Management. So the work of the Council of Urban Environment is not new. It's been there for some time, and I'll come to it, but you will see also there decisions of the European Court of Human Rights, which spanned many years back. But I think what has changed is or at least what changed for us was the summit of heads of state and government of the Council of Europe in Reykjavik in 2023, where the leaders of the member states of the Council of Europe decided to put environment very high on the agenda as a priority in order to allow the organization to contribute to the efforts of the international community in addressing the triple planetary crisis. And why do I mention that? Because, of course, that crisis has to do with climate change, with pollution, and with loss of biodiversity, and I'll come to it. But also, the leaders reaffirm, so heads of state and government reaffirm the political recognition of the right to a clean, healthy, and sustainable environment as a human right, committing to reinforce the work of the organization on human rights aspects of environmental protection. So by saying this, I'm already actually answer a little bit your question. Do we have the right in the Council of Europe setting, that right in the Council of Europe setting? And so we do have a political recognition at the highest possible level, heads of state and government, reinstated in 2023. We also have before that a recommendation of the Committee of Ministers to the governments of member states precisely on this and asking them to enact that right at national level. But yes, you're absolutely right. We do not have, as of today, a legal instrument which recognizes this as a self-standing instrument. We have, and we heard some of these earlier this morning, seen decisions of a court, and I said there are more than 300 decisions which touch one way or the other on environment, and we have a batch of such cases which are quite important coming in 2024, which were in a way a game changer. And of these three, there were three cases in particular which came more or less at the same time that the court decided to process in one group in the Grand Chamber. And of course, as we heard from my colleague from the court, the Klimasignorinen, I'm sorry, my German is not so good as hers, so I cannot pronounce it properly, was obviously very important. I mean, the court did not recognize the right to a healthy environment. What the court did, as it has done before, is use existing substantial and procedural provisions in the European Convention on Human Rights in order to advance the cause of the protection of the environment. And I think what is fair to say is that in those judgments, the court did really with as much as it could in terms of not only establishing the link between the inaction of governments to implement the commitments they have taken and the damages to the enjoyment of human rights, but also in providing a special regime for associations, the so-called Klimasignoren NGO stand, on account of special considerations. The court used language such as existential crisis for humanity. It also introduced a new principle of intergenerational burden sharing, a number of other important things. I think this is part of this dynamic interpretation of the European Convention of Human Rights that we see in many instances, and not surprisingly, we're seeing it also in the area of environment, but again, using the existing substantial and procedural rights enshrined in the convention. One of those of a procedural nature, access to court, is one of those where the court found a violation in the case of this Swiss case. What is interesting is, and we heard that as well, is that one thing is the decision of a court, then comes the execution of a judgment. And here we see interesting positive developments, not only in this case, but in other that I will refer shortly. For we have seen that as a result of that, since the execution has been considered, and there was a recent consideration still this month, Switzerland moved to adopt a comprehensive legislative and regulatory framework at federal level, setting out goals, targets, and a timetable for achieving zero net emissions, accompanied by a range of relevant measures at cantonal level. Switzerland also, by a method of choice, quantified the future greenhouse gas emissions corresponding to the general measures, and the target timeline was put in place. This is not the end of it. There are still aspects of a judgment that need to be implemented, particularly when it comes to access of NGOs to cases. But what I want to say is that things move. So they go in the right way using existing provisions without a separate self-standing right to a healthy environment. So those cases were relating to climate change. But now we see a series of cases relating to pollution, which again are not new. They're recent ones, including the most recent is this Italian case, the Cannavacciuolo and others versus Italy, which, as I said, concern pollution. In this case, concern dumping, widespread dumping, burying and burning of waste on private land for decades. And of course, not surprisingly, the impact that had on public health and in particular the health of individuals. What is interesting in that case is that the court found that failure of the Italian state to tackle effectively these environmental issues amounted to a violation, again, not surprisingly, of substantial rights in the convention, starting with the right to life. And in line with a precautionary approach, it considered that the state could not use as an argument that it couldn't establish the link between that and the damage to individuals as an excuse not to comply. And again, interestingly, in the execution phase, and this is recent information, the Italian authorities informed the Secretary General of the recent adoption of urgent legislation strengthening the criminal response to environmental crimes. What clearly illustrates the impact of the judgments of the European Court of Human Rights on national legislation and the protection of environment. Along these lines, I also want to mention the adoption in May this year of a new Council of Europe Convention on the protection of environment through criminal law. So what I'm trying to say is that there is a myriad of different logics of intervention which are contributing effectively to the protection of the environment. The European Committee on Social Rights, which is the one that follows the implementation of the European Social Charter, is also in its conclusions and findings pointing to areas of improvement in relation to the environment through addressing the social consequences of environmental degradation. But as I come to your fundamental question, where do we stand? What's happening? Is there going to be the right to a healthy environment enshrined in an international treaty? I think you are all familiar with the debate and the way. You know that our committee of steering committee on human rights has been considering the feasibility of drafting one or more instruments on human rights and the environment, which basically boils down to, do we have a protocol to the European Convention of Human Rights, enshrining this as a separate right? Do we have a protocol to the European Social Charter? Do we have a standalone convention on the environment, which would include these various aspects, not only the enshrinement of a right to a healthy environment, but also aspects relating to the content of this right, whether there's information, whether there's access, etc., etc. A combination of all of these and a number of other possibilities. The feasibility study and the ensuing summary presented to the Committee of Ministers in this respect was examined. And at the ministerial session in May, the ministers instructed the organization, the member states, the ambassadors basically who meet on a regular basis, to move forward as quick as possible with the consideration of this possible binding or non-binding instrument. And this is where we stand today. So the decision on follow-up was taken in June this year. And we will see additional consultation between the capitals. I think it's clearly understood that now this is a political decision that has to be made. Interestingly, the political recognition of the right to a healthy environment is there, as I said, because it stems from the summit itself, and in turn is based on the General Assembly of the UN recognition. So we have that political support. We seem to have some difficulty to translate that into a legal text, and I think the difficulties are also connected with the system in place. I mean, the European Convention on Human Rights is a well-established system, a very successful system with a monitoring body, a court, an independent court which adjudicates, but some states consider that it is difficult to integrate these type of cases into the functioning of a court without perhaps affecting its function negatively. But there are a number of many different views and considerations. I think, as I said, that the work relating to the options has been done. I think everybody has a very clear understanding of what are the different options and what are the consequences. Perhaps there's more on what is the impact that any of these options, and in particular the option relating to the drafting of a protocol to the European Convention of Human Rights would have on the functioning of the court. And we do hope that we will see some movements in that front in the coming months. A report will have to be presented to the Committee of Ministers by the end of this year, and no later than I think the next ministerial session, the Committee of Ministers will have to take a position. Ma'am, I'm sorry I've abused my time, but I just wanted to bring you back to this strategy on the environment that was adopted in May this year, and not surprisingly, strategic objective 1 deals with the recognition of the right to a healthy environment. So it's pushing for a recognition of this right at national level. It's perhaps a little bit more than what was done by the Committee of Ministers in 2022 when adopted a recommendation addressed to the governments of member states. Now we have pushed this a little bit further by having the Committee of Ministers adopting this strategy and setting out as strategic objective number 1, precisely promote the recognition of the right to a healthy environment in member states. Now, I have to say as well that this right is already enshrined in the constitutions and legislation and laws of many, if not most member states. So that will continue to happen. And no doubt we know and we understand the keen interest on seeing this also happening in the Council of Europe setting at the international level, and we'll certainly work with you in that respect. I understand some of the UN rapporteurs are attending this week's proceedings in the Parliamentary Assembly of the Council of Europe, and we are actively engaged with them in the Intergovernmental Committee on Environment and also in some other related events, not least the COP30, which is coming up. Thank you for your attention, and of course we remain at your disposal for any questions that you may have. Thank you.
Thank you, Rafael, for this update, which is very, very useful. And also to remind us that that is also another practical example. For example, what you said, the special rapporteur are involved in the interparliamentary commissions at the Council of Europe level, but also, you know, when we were discussing the execution of the European Court judgments, you know, how do we, for example, again, as a practical recommendation or example, how do we use all the various tools at the international level, in particular, to encourage states to implement their judgments of the court, for example. And I know that some special rapporteurs have been trying to do that. So how can they help pushing this execution further? And it's really good to hear that there is dynamic interpretation of the European Convention in relation to the right to a healthy environment, and work continues. As you know, at the political level, they keep debating whether they want an instrument and eventually what form that instrument may take. So that's always very useful. We have come to the end of the panelists and almost at the end of the panel, but we still have some time for continuing the discussion, inputs, comments, questions for our panelists. Any reflections? As I said, we were meant to come out of these two panels with practical solutions-oriented recommendation that will feed into the report also of this conference, also because probably in 2-3 years, we are going to go back and look what have we done in order to implement the recommendations or to follow up the recommendations. So it's useful to that we try and bring that now. We still have tomorrow, but I think we have had very rich discussions and contribution from the various panelists. So anyone wants to intervene at this stage? Sebastian, you want to come in at this point, or Elisa, Astrid? Yes? Okay, go ahead, Sebastian. Thank you.
Thank you so much, and thank you for the great presentations. One of the things that comes to mind for me as a practitioner, and I wonder if it also echoes what your own experience is that I hear questions about the feasibility of various developments. I hear also a lot of different experience in different regions, actually, with concrete challenges in implementing the right. And so I just wonder if having the possibility for the different regional bodies to meet earlier than in 3 years to discuss the experience, even if it takes place online, or finding some opportunities to share good practices could actually be something very useful. It seems there is so much happening at the moment, so many challenges, but also so many lessons in different corners of the world, that it would be a missed opportunity to wait another 3 years to really formally exchange about the lessons learned across regions. So I wonder if this is something that panelists will find useful, maybe to accelerate the cross-fertilization across regional bodies, keeping in mind, of course, the specificities in different institutions.
Yes, thank you, Sebastian. Very practical recommendations. We'll hear what the panelists think about it. I don't know if Astrid, Elisa, you want to come in at this point? Yes, Astrid, please.
Madam Chair, I have 2 points. One, following up what Sebastian was mentioning in terms of following up from this from this workshop, sorry, and linked, I didn't have the time to mention, but from special procedures, there are several reports, not only from my mandate as a special rapporteur in the human rights and environment, also from my colleague that is here on special rapporteur on climate. But there are many others, including toxics, water, many others that I was going to say, also the working group on business and human rights. And in addition to the reports, there are several information from communications that we sent, both other letters and other also allegation letters. And so I wonder how much, and this is the question, how much this is something that the regional international mechanisms use. And to me, I think that there's a very important way to, and ways to follow up from that, including the recommendations. The other one is a question. It's a little bit about implementation, but it's also a question for both all the panel, but mostly maybe for Javier and Mr. Benitez, or Mr. Paluma and Mr. Benitez, about the decisions from La Oroya. Specifically, one of the things that the court recognized is that whenever there is a risk created for human rights, specifically for the right to healthy environment and health, and there is a proven existence of contamination that includes a significant risk for health of people. And then there's also the evidence of exposure of people and the fact that the state knew about this level of exposure. And then there is a change of the evidence of proof for people that and this is what the court mentioned in La Oroya, and then the European Court also mentioned in Cannavacciolo case, that people, the defendants are not necessarily have the duty to demonstrate a direct causation between health impacts and the damage, but it's for the state to prove that there's no damage, because this is one of the huge, most wonderful, I think, contributions from these cases. This also shows how courts learn from each other and pollinize, as I mentioned. So I wanted to ask you how much this has been used and the potential to use not only in these courts, but also other spaces. Thank you.
Thank you, Astrid. I can go back to the panelists. Elisa, yeah.
It's also how different institutions are able to advance on maybe slightly different angles of the relationships between human rights and a healthy environment. And maybe that is the space for mutual learning as well. I'm really thinking about the aspect of the intergenerational equity and how human rights exist in international human rights instruments, and also evolutive interpretation can help to fill with very specific content that aspect of intergenerational equity and intergenerational impacts. So I'm just wondering if the colleagues have maybe more to say about what they've either been learning or where think they can build upon from other regional bodies, or equally if there is a space, a topic where we could convene or include in the recommendations more support for mutual learning on this. And maybe just to emphasize the important role of children's human rights in this context, but as well what we've been learning around impacts on older people and of course the advancements in terms of human rights of future generations.
Thank you. So who would you like to start? Anyone else from the floor? No? So who would you like to start? Rafael? Yes, please.
Thank you. Perhaps at the outset, I very much take it from the two special rapporteurs. I think one of the examples how we can work together is actually what we're doing. I mean, you are participating in a joint event we're doing in the COP on misinformation and disinformation. And interestingly, that event is moderated by a young person. And I want to say as well that in the work which led to the adoption of the strategy of the Council of Europe on environment, the youth were represented at all times during the negotiation, which made actually the governments wonder at the beginning, but then very quickly they understood that this was part of the way the organization is proceeding these ways and accepted. And in fact, again, those cases that I refer to, not just the Swiss, which was old ladies, but also the Portuguese, which was exactly the opposite, young people, pointed precisely to these different dimensions. Now, on the question of the link and causation and all of that, I have to say, the difficulty here is that we are addressing at once many different aspects, from highly legal, technical aspects, and I would invite those who are more interested in that to perhaps see the videos from the European Law Institute 2025 discussion, which took place in Vienna last week, attended by basically presidents of Supreme Courts, former presidents of the European Court of Human Rights, practitioners, corporate lawyers, you name it, where very specific things such as locus standi, legitimacy, link of causation, corporate liability, accountability, all of these things were addressed. And I think it's a bit difficult to address them. I mean, this is here we have a forum where we're discussing, we go from very political recognition to very diplomatic discussions to very legal aspects. So I think it's a bit difficult. But what I want to say is that if you look at Klima Senioren, what you see is that the court allow a special channel for NGOs, the new Klima Senioren regime. At the same time, it increased the threshold for victims. Now, interestingly, it's more difficult for victims. And in fact, interestingly enough, some of these old ladies unfortunately died in the process. But it's interesting. So yes, things are changing. Then when you look at the Italian case you referred to, this is not on climate change. This is on pollution, and yet the special regime is for climate change. It's not for pollution cases. So this is all evolving, and I think it's difficult to address it here. On the intergenerational equity, obviously this is key, and this is one of the aspects which features high, not only on that case of court, but also on the strategy and the whole approach of the Council of Europe. This is not just a discussion between governments. This is a discussion between all components of society because it concerns everyone. And I think this is a lesson to take and to respect, because it's not a discussion for scientists. It's not a discussion for lawyers. It's not a discussion for politicians. It's a discussion where everybody has to contribute. And I think this is very important.
Thank you, Your Excellency. Would you like? No, it's okay. So we go to, yes.
Thank you to give me the floor, Madam Chair. I'd just like to hear the importance of this very important topic, like the clean health and environment. We may look at this very critical theme because today Africa is the continent to face the most challenge of the critical environment. If we look at how climate change are impacting children's rights in Africa, we may look careful and say we need to do something to improve the quality of life of the African children. We cannot forget that Africans is the continent who less pollute the environment in the world, but face the worst consequence. And sometimes international organization created some mechanisms as the the carbon and others, but we still are not doing enough to make a real change in the children's lives in our continent. If we look better, and as I stated today, we have many double standards in the international organizations that we look in one perspective what's happens in Europe, in Palestine, and other countries, but we don't look the same way when happens in Africa, or South America, and other continents. This is why something that I would like to address for my colleagues of regional human rights mechanism is that human rights boards cannot be political. They defend the human peoples. They put on the top of the agenda the human dignity, and we must be who lead the international organization by moral standards. And it's very important for us to prevent double standards in our international organization. Thank you.
Thank you very much, Javier.
Sí, muchas gracias por las preguntas. Voy a responder de forma más breve posible. Primero, Sebastián, hay muchísimos aprendizajes y muchas cosas positivas, pero la pregunta fueron desafíos. Por eso hice un énfasis en los principales desafíos. Pero evidentemente que hay muchos aprendizajes. Para el sistema interamericano, nosotros contamos desde 1988 un texto convencional, el Protocolo de San Salvador, que reconoce el derecho al ambiente sano. Pero hubo que esperar hasta el 2017 para tener una interpretación de la Convención Americana, de la Corte Interamericana de Derechos Humanos, que habilitara la responsabilización de Estados por este derecho a reconocerlo como reconocido en la redundancia por toda la Convención Americana. El aprendizaje detrás de esto estaba vinculado evidentemente con la interpretación progresiva, sexista, los textos del sistema interamericano. No voy a profundizar en los tecnicismos del largo camino y las etapas que ha transitado el sistema interamericano para llegar al punto actual. Lo ha hecho la representante de la Corte Interamericana en el panel anterior, pero es algo que da cuenta de una situación muy positiva desde el punto de vista del reconocimiento de derechos. Lo segundo, que creo que es un aprendizaje clave para la región, está vinculado con la importancia del encuentro entre el movimiento de derechos humanos, esta ambientalización, otra vez, el movimiento de derechos humanos, y también cierto acercamiento del movimiento de protección del medio ambiente hacia los mecanismos y las herramientas del sistema interamericano de derechos humanos. Esta posibilidad de contar hoy día con una sociedad civil que reúne al ambientalismo, al activismo ambientalista tradicional, al movimiento de derechos humanos, a las comunidades locales organizadas, a los pueblos indígenas, es una herramienta fundamental para sostener lo que se ha logrado para fraccionar implementación, operacionalización, etc. O sea que hay cosas muy positivas que tenemos sobre la mesa que antes no teníamos. Primero, tenemos un derecho que es reconocido como exigible en la Corte Interamericana, y segundo, tenemos una sociedad organizaciones, movimientos que de alguna manera constituyen la causa y del reconocimiento de estos derechos y estas luchas, pero también un factor clave para avanzar. Astrid preguntaba, la redactora especial, preguntaba hace un momento sobre los usos del trabajo de las redactorías especiales de Naciones Unidas. Creo que la opinión consultiva de emergencia climática y derechos humanos de la Corte Interamericana de Derechos Humanos habla por sí misma. Referencia al trabajo de las redactorías especiales, en este caso especialmente el trabajo de la redactora Morguera en múltiples oportunidades, más veces que a la propia Redactoría Especial de Derechos Humanos. Así que creo que existe un trabajo muy claro en el sentido de acumular esfuerzos y energías. De la misma manera, el sistema interamericano de derechos humanos tiene una tradición, a través del concepto del corpus iuris, de enriquecer la interpretación de las normas del sistema interamericano con instrumentos normativos, inclusive el soft law, y otros sistemas regionales y del sistema universal. Y esa es una tradición que empezó en la década del 80 con Villarán Morales, Niños de la Calle, cuando se incorporó la Comisión Internacional sobre los Derechos del Niño, la interpretación del artículo 19 de la Convención Americana, y a partir de entonces hasta ahora existe una práctica consistente de la Corte Interamericana de Derechos Humanos de relacionarse, llamémoslo en sentido amplio y poco técnico, con los productos de otros sistemas regionales y del sistema universal. Y la última pregunta que quiero responder está vinculada con estándares de prueba. No lo mencionó el sector especial, pero también de legitimación activa. Y ahí tenemos un tema relevante de adecuación normativa desde mi punto de vista. Muchos de nuestros países, los países de América Latina, cuentan con acción clave para la protección, garantía de los derechos humanos, inclusive el derecho al ambiente sano, las acciones de amparo. Las acciones de amparo en general han sido reguladas como excepcionales, con regímenes que no se pueden caracterizar como proacción, sino en muchos casos regímenes en los cuales la parte demandada, el Estado, se encuentra en una situación especialmente privilegiada. Y tampoco existe en varios de nuestros países modificaciones del régimen de prueba, sea una aplicación fuerte de la teoría de cargas dinámicas de la prueba o inversión de carga de la prueba. Creo que son desafíos que tenemos por delante, pero no son los únicos. Muchos de nuestros países tienen legislación de evaluación de impacto ambiental desde la década de los 90. Que evidentemente no recogen mucha de la evolución que ha habido en términos de, llamémosle, impacto del derecho internacional de los derechos humanos en las políticas ambientales y en las políticas climáticas. También desde ese punto de vista es interesante pensar agendas de adecuación. No solo, vuelvo a decir, vinculado a los remedios de carácter nacional, la incorporación de estándares de avanzada vinculados a prueba y legitimación activa, sino también vinculado a la normativa que regula las evaluaciones de impacto ambiental. Entonces, no quiero extender mucho más. Gracias por las preguntas.
Thank you very much. Thank you to all the panelists. So I take it that Sebastian's suggestion to, oh yeah, sorry, go ahead. Sorry.
Just jumping because the court's judgments have been over quite a lot in this afternoon's discussion, and understandably so, because they provide quite a significant part of the possibility to vindicate rights and enforce them when it comes to environmental protection. I just wanted to draw together two strands of things we discussed, and I know that you want to close, so I'll be brief. It was the issue of causation was raised in the context of the Cannavacciolo case, and I just wanted to flag that the court doesn't use, in fact, so much this phrase as it talks about a real and imminent risk, which is something that comes from the court's jurisprudence under Article 2 concerning the right to life that dates back many decades. And the court has this in the jurisprudence concerning, for example, cases that concern unlawful action of security forces, as much as it's applied them in environmental cases over the decades, like Brincat against Malta, asbestos, or Yildiz against Turkey, which concerns unsafe disposal of toxic waste. And I mentioned this just to flag that the court is doing something definitely important in the Cannavacciolo case, but not necessarily something new as such, because we talked about dynamic interpretation of rights, and I understand why that's so, but from many perspectives, the court simply using the existing rights and jurisprudence it has and applying them in the cases that are brought before it. Can't choose the cases that come naturally. And that's why many commentators have observed that cases like Klima Senioren or Cannavacciolo, they're cases about rule of law in a way, as much as they are about the environment, because the state's confronted with a risk and then it has a responsibility to act in order to accommodate that risk, whatever its nature, mitigate that risk rather. So I mentioned this because the court's decisions were flagged in the context of wider discussions about, the direction that the Council of Europe may go to recognise the right to a healthy environment. And of course, we must have regard to the court's case law, which has provided an important context here, but ultimately, naturally, the political decision about that lies with the states, as Director Benitez has explained so well. Thank you.
Yes.
Just one.
Yeah, please. Sorry, we have.
Okay, thank you, Madam Chair, for just to add that on the continental level, the African Charter of Human and People's Rights recognize the right under the Article 24. And the committee can draw inspiration from the Charter as the Article 46, which mandate the committee to draw inspiration from similar mechanisms. And finally, I would like also to address that our general comment of number 5 interpreted the best interests of child on the long term, including protecting the rights of future generations by protecting the environment. In this term, the working group together, the committee see the opportunity to leverage on existing norms of United Nations and other regional mechanisms by adapting in all children in Africa. Thank you.
Thank you very much for yours and yours, Wilson, important contribution and addition. There seems to be there's no doubt about the cross-fertilization that is allowed by international and regional mechanisms. And so this is very important and we can only build on that. And I was saying that I guess there were no objection about Sebastian's suggestion for the relevant regional and international mechanisms to come together before a little bit earlier than 3 years time, because there is a lot going on all this front. So it would be that could be part of the recommendation, and we could see also the modalities on the Cannavacciolo case. I just want also to mention that there was cross-fertilization because the Special Rapporteur on Toxic and Human Rights visited Italy and took up exactly this case, and there are references to that special rapporteur country visit report in the jurisprudence. So this is another way for cross-referencing and cooperation. I guess I'll leave it at that because we have gone beyond the allocated time. Thank you very much for everyone, our panelists and the public. A big round of applause, and I'll see you tomorrow, I think at 10 o'clock. Yes, see you tomorrow. Thank you very much. Have a good evening.